God, Amina, our client just died. What do we do next?
I don't know, but you better stay tuned to find out and see. Hi everyone, thanks for tuning in.
Make sure you like our video and subscribe to the Ladies in Law.
Yeah, you know that little heart and thumbs up at the bottom of your screen? Click it before you do anything else.
Right, because legal news like this is too hot to miss, and we're bringing it to you every Thursday at 3 p.m. I'm Rippy.
And I'm Shake.
And we're the Ladies in Law,
where we're ripping and shaking up all the legal information you know, need to know, and want to know.
From the tabloids to the courthouse to your own home.
So for this episode, we're going to do an overview of Michigan's probate process. What happens after people have passed away. We recently did a video on estate planning, which is what you need to do before you die. Yeah, but you also need to know what's going to happen after you pass away and what you should do, what you should know to look out for, and the people that are your loved ones that are having to handle it.
Yeah, usually your children. Or
usually the children.
Yeah.
Yeah, so the first thing and a very important thing is you should know that there are so many assets that don't need to be going through probate. That you can, prior to passing away, ensure that they will automatically go to your beneficiaries. This is putting a beneficiary on your bank account, maybe life insurance policies, some retirement accounts, house deeds. All of those sort of things are super, super, super important, and you just don't have to deal with probate then because of it. And also, one that we did talk about before is assets that are held in a revocable living trust. So there's two types of trusts. Got to check out our video on those to know more about it. But assets that are in a revocable living trust don't have to go through probate either.
Right. So now if the deceased person was receiving Social Security benefits, the Social Security Administration needs to be notified right away, like as soon as possible, that the person has died so that they know to cut off the benefits. Now, if a payment happened to be made after the person has died, the Social Security Administration can come back and claw back that payment, and a lot of payments nowadays are through direct deposit, and they'll just withdraw it directly from the account. Now, there are instances where people fail to notify the Social Security Administration and try to, be slick and keep collecting the money even when their parent has died, and in some instances it's been like 10 or 20 years.
Oh yeah, long time.
But the Social Security Administration eventually will find out. So whether they find out 5 years, 10 years, 20 years later from now, they're going to find out, and then you're going to face all these federal criminal charges, as well as they're going to try to get their restitution, seek back this money from you. So make sure that you notify ASAP. We
actually had in a divorce where the divorce was getting very contentious, and our client knew that their spouse had done this with her father and wanted to use that as part of the divorce. That's some bad dealings, but hey, it can come out. I mean, it will come out, and it can come out of more ways. It's very bad, basically.
Now, when a person dies, whoever is administering their estate, whether it be a personal representative or executive or their children that's handling any heirs, they need to file for a new tax ID number for the estate, which is separate from the tax ID number of the individual. So normally us as individuals, we use our Social Security numbers, but the estate is viewed more like a business where they have to file for an employer identification number, an EIN. And that number is the number that's used to handle business affairs for the estate. For example, opening new bank accounts or brokerage accounts, as well as filing that final deceased tax return with the IRS.
Right, so it's super important to know these little intricacies. Who would have thought that an estate would appear more like a business
and have its own
EIN number, right? Okay, so the next thing that you need to know is, how does an estate need to be administered? Now, you automatically are thinking, it has to go through probate. No, not necessarily. There are smaller estates that don't need to necessarily go through probate, where the court's little, if any way involved. And these estates, for 2019 was at the maximum the estate was worth $23,000. For 2020, because of inflation, it would be $24,000. Well, here's the interesting thing. This seems great. This is like a much quicker process. It has its own legal inheritance formula it follows, which I'm going to go over in a second. But if there is a will in place, yet there's a smaller estate, and it's like, oh, I don't want to have to deal with probate, I want to just get it done, the will be completely pushed to the side as if it's not there, and you have to follow this formula instead if you elect to do the smaller probate or the smaller small estate process. And this legal inheritance formula is kind of straightforward. First, everything goes to the spouse if there is a spouse. Yeah. If there isn't a spouse, everything goes to the children if there are children, and then split equally among the children. Mm-hmm. Now, if there are no children, it goes to the grandchildren and split.
Or if one of the children has died,
right,
that child share goes to the grandchildren.
Right, and it's always equally split. So it just keeps kind of going down this manner. And a lot of people, we've had clients that would prefer to get that done because probate court is can be a tough thing to go through. So that's one way that an estate can be administered if it's a small estate.
Mm-hmm. Now, let's say the value of the estate is over the $24,000 or $23,000 that Amina was mentioning for 2020, 2019. Or if the estate is within that value, but the heirs want to follow the will instead of using the legal inheritance formula, then the estate needs to go through probate court proceedings.
Yeah.
Now, there's two types of probate court proceedings. There's informal proceedings, and then there's formal proceedings. Informal proceedings have fewer steps, easier to get the probate done, a quicker process. But at the same time, it's heard by a probate register instead of a judge. So if you want a formal process and you want kind of a judge's stamp on it, you want to go through the formal probate process. So we see this typically when there's contention over the property, how the property will be divided, who will be the personal representative or administer to end up administering the estate. You want to make sure that you have a judge because that's a more final decision, and you want to go through the formal probate proceedings. Because
a lot of people will be litigating all through probate and post the probate process being done, saying, no, this wasn't done right. That wasn't done right. There's nothing stopping them from doing that.
They can always, even after you've closed an estate, that someone can always file a petition with the probate court to reopen the estate.
And a lot of people do it.
To handle whatever issues that they feel like have arisen. So we feel that with handling with a judge, it makes it a more final, more concrete decision, because with an informal proceeding in front of a register, you can always appeal.
It's a lot easier to appeal, and then you have to go to a judge.
But at the same time, we have clients who, maybe over the small estate number, but everything is straightforward. So they just, we'll go through the informal process because it's quicker, it's going to cost us less money, take less time.
You just have to know your situation.
Exactly. So if you choose to go through the formal probate process, there's two types of formal probate: unsupervised and supervised. Now, by far, most of the cases are unsupervised, where the judge only gets involved at the very beginning when the estate is first open. The judge will appoint whoever is going to be the personal representative or the executor, and then the judge gets involved at the end, when that person is trying to close out the estate, and the judge is reviewing to make sure that things have been handled properly. The other type, supervised, is when there's very contentious estates going on, where heirs are fighting, usually high value estates, where anything that is done, any decision, any property or money that's moved in or out of that estate needs to be checked by the judge.
Finalized.
There's
conferred on.
Judge oversight during the complete step of the way.
And as attorneys, sometimes we have to, we ask our clients, what is your situation? Tell us about it. And they'll come, and we then have to evaluate as an outside perspective, knowing the law, knowing the process, and saying, we know that this is something that you don't really want to have supervised, but trust us. This, for example, this is something you want to have supervised based on the things you're telling us. Or there'll be times where, I know you feel like you need to have all those checks, but you're really going to be wasting your time.
Like I said, the overwhelming majority of probate cases that go through the formal proceedings are unsupervised.
Yeah. So hopefully you don't get sued after. But anyway, so that was like a very general overview of the after someone passes away and what you need to do, which is like very important with everything going on in the world. Generally it is, but even more so in the light right now. But there are just a couple main points that we want you to remember. And the first one being, many assets don't have to ever be probate. They can be automatically transferred to a beneficiary. So handle those: life insurance policies, house deeds, things like that, bank accounts. 2, if there are Social Security benefits, let the Social Security Administration know immediately. You do not want to have to do a back pay. And don't try to be slick. You will likely get caught. We have seen it happen. 3, income taxes. The state now becomes the taxpayer for the person that passed away. And like we were saying, it's kind of funky, like actually has to get an EIN number. It's not just like an individual now, it's viewed more like a business. 4, there is a simplified way of administering this estate, which doesn't have to go through probate when the estate is small, 23 to 24,000 at most. But the issue becomes, do you want to if there's a will that has clear direction? Because the will, if there is one, gets disregarded and a legal inheritance formula is applied. So you got to figure out what you want to do with that. And 5, there are 2 types of probate process: informal, formal, and within all of that, there's supervised, unsupervised. You just need to balance out and listen to your attorney who has special knowledge on what's best for your situation and the estate situation. So those are the main points you need to know. Super important to know. So thanks for watching, and make sure you like and subscribe to the Ladies in Law so that you get all the hottest legal news every week.
That's another episode of Ladies in Law, not your average lawyers. Rip it up, shake it up, rip it up, shake it up, rip it up, shake it up.